Welcome to OnAir with Akin. I'm Jason Daniel, a investment funds regulatory partner in the Dallas office.
And I'm Barbara Niederkofler, an investment fund partner in the New York office.
Welcome to the third of a three-part podcast on regulatory changes. The first podcast dealt with recently adopted rules and other actions. The second part dealt with proposals that were still out there and had not yet been adopted. This third part will take those first two parts and we'll talk about how it impacts your fund documents and your procedures. First, let's talk about the impact on documents of a recent whistleblower case where the SEC took action due to a large bank, including provisions of confidentiality in settlement agreements with their retail customers. So if you have a confidentiality clause, you need to consider potentially adding in language allowing the person who's subject to the confidentiality provision to make reports to an appropriate regulator. Exactly how much depth you want to go into, your mileage may vary. A lot of times we feel that less is more on that.
Yeah. The second item to consider in terms of updating your fund document is in relation to the SEC's guidance in the private funds rule adopting release, as well as in the 2019 fiduciary release, that both negatively comment on the use of hedge clauses or other language that may give the impression that fiduciary duties under the Advisors Act are waived. And the SEC's views and requirements are somewhat at odds with the requirements under local law, or particularly Delaware law, that all fiduciary duties may only be varied by contract as opposed to disclosure and consent. So advisors may wish to review their fund documents in light of the private funds rule release and the fiduciary release from 2019, and whether any changes or clarifications are needed in the fund documents.
So the next thing to consider is potentially trade errors. Barbara talked about the standard of care and indemnification concerns. Similarly, you should consider your trade error policies.
Another item to consider, and this is one that has been around for many years, is expenses. But particularly in light of the private funds rule, advisors may wish to consider the impact of expense provisions under the rule regarding expenses associated with an investigation, compliance expenses, clawbacks and the effect of taxes, any non-pro rata charges of expenses for portfolio investment, and aligning expense categories with those for quarterly reporting to which the registered investment advisors are subject under the private funds rule quarterly statement rule. However, given the regulatory uncertainty regarding the fate of the private funds rule and the Fifth Circuit decision, it is likely premature to adopt many of these changes, especially changes regarding the clawback. But they are certainly worth thinking about, especially if the private funds rule is not overturned. So similarly, while not an expense, in light of the private funds rule, advisors may also consider any potential language that may be deemed to be a loan to the investment advisor or its related persons, and how that would need to get disclosed in the fund document.
Next is the Form PF, the categories in the subscription document of the type of investor. You should reconsider that and consider revising those. That is not effective for a year, but that's something that will impact the subscription documents.
And so while this is not from the SEC, another item to consider for your fund documents are the confidentiality and further assurance clause for the CTA and the New York LLC CTA, as well as the AML compliance. We would recommend reviewing the subscription document language regarding further assurances. We mean by that to provide further information, to confirm that the fund has the ability to require cooperation in connection with filings with FinCEN or New York under the new laws, and an acknowledgement that investors may be disclosed in reports to FinCEN or New York. Along those lines, advisors may also consider including a risk factor on this in their PPN.
Speaking of risk factors, there are a few items that came through that we talked about earlier. We talked about the dealer registration rule. So if you think there's any risk that you may be implicated there, that the fund may have to register as a dealer, it's worth including a risk factor. Finally, if you think there's any risk under due to the predictive data analytics rule, if that's adopted, you should also consider a risk factor there.
So thanks for listening in. I know that we've covered a lot of information, but we hope that the 8 or so items that we've just discussed on fund documents and potential updates are helpful. Thanks again for listening in.
On Air with Akin is presented by Akin and cannot be copied or rebroadcast without consent. The information provided is intended for a general audience and is not legal advice or a substitute for the advice of competent counsel. Prior results do not guarantee a similar outcome. The content reflects the personal views and opinions of the participants. No attorney-client relationship is being created by this podcast, and all rights are reserved.